Hello everyone, my name is Elvis Abenga from BEGI'S Law Offices and Chambers. I'm here to give you a short tutorial on estate planning. Estate planning is a very important tool nowadays. We're living in the last of the last days, and life is hard. Life becomes sometimes very unpredictable. Estate planning allows you to have a little bit of control over your life, both while you're alive and even after you pass away in the unfortunate incidents that you pass away. So I'm here to just give you a brief background to estate planning. At this point, say that we are just scratching the surface of it. There is a lot that goes into estate planning, but I want to just take time to talk about it in brief, just what you need to be able to get, just as you think and consider planning for your estate. Before I get into the nitty-gritties of estate planning, I'd like to tell you who we are. I run a law firm called BEGI'S Law Offices and Chambers. We are a theocentric law practice with the goal of meeting clients' needs through quality legal consultancy, representation, and advocacy. When I talk about it being theocentric, what I mean is we have God, or we try to have God at the center of our practice. We believe without Him, we cannot exist, and I am not ashamed to mention this publicly, that God is the center of this practice. That being said, we have 13 practice areas ranging from family and children law to commercial law and corporate legal consultancy and advisory, to conveyancing, to constitutional law and human rights, to civil and criminal litigation, as well as alternative dispute resolution. These are what we call our anchor practice areas, and we'd be very happy to support you in any of these areas. Before we get into this conversation proper, I'd like to introduce you to the eConsult portal. The eConsult portal is a portal we established in our website, www.begislaw.com/eConsult portal, where we are able to log in. You can log into you can create an account, log in, pose your questions, and we will be able to answer them and set up consultation sessions and help you out. So if you, even through the course of this webinar, you have a question you'd like to answer, to be answered privately, please reach out either directly or through the eConsult portal. So what is estate planning? Estate planning is an action plan that you can use to determine what happens to your assets and obligations while you're alive and after you die. So when we do estate planning, we come up with a plan, and this plan begins while you're alive, giving you control over your property and extending all the way to even after you're no longer alive. It gives you some certainty of an uncertain future, some level of peace of mind. You don't want to worry that maybe if you pass away, your property will be misused, your children will be harassed or not taken care of. When you do a proper estate plan, you set us up legal mechanisms that enable you take charge of your affairs and ensure that you have peace of mind that even if you're gone, your property will be taken care of properly, your children will be taken care of properly. So what are the benefits of estate planning? One, you protect your minor children. Two, you are able to express your desires for what we call end of life care, or that is after death care. End of life is just before you die. Maybe you're in your deathbed. How do you want to be treated? Do you want to recover from home? Do you want to be in hospital? That is called end of life care. People are actually able to do that nowadays, and we'll talk about it later. You're also able to specify how you want your assets to be distributed. You are also able to create what we call a living legacy. You are able to leave a legacy through what we call a continuing trust. We'll talk about continuing trusts later. And you're able to maintain control and some flexibility during your lifetime. So let me just take time to talk about 7 steps to estate planning. Step number 1 is finding a qualified advocate. And I do hope that you will consider BEGI'S law offices and chambers as that qualified advocate, where we can be able to help you through your estate planning process. 2, you take stock of your assets. It is very important to take stock of your assets, because when you go to a lawyer, the first thing the lawyer will ask you is, what are your assets? Are you able to identify what are the values? You need to know what you have in a nutshell. You need to also, 3, identify some key individuals, that is executors, that is trustees, who are able to support you through the estate planning process. And we'll talk about executors and trustees later on. You are able to identify the tools and documents that are needed. You need to be able to manage documents. Sometimes this process requires a lot of modification of documents. You ask yourself questions: who is taking care of my documents? Are you going to leave your documents in a safe somewhere, or are you going to leave them with your lawyer, or who's going to keep these documents? Then we also talk about soft planning, that is non-asset based estate planning. This is based on things that are not related to assets. For instance, what kind of education system you want your children to be taken care of, to go through in the event of your death, what kind of religious upbringing, all that kind of stuff. That is called soft planning. And then you also establish a review schedule, which tells you how often this estate plan needs to be reviewed, because things keep changing every time. You might have executors or trustees whom you're in good terms with today. After a couple of years, you're no longer seeing eye to eye. You need to remove trustees. You need to change executors. You need to update the new assets that you've bought. That is part of estate planning, a review schedule. So these are the tools that we call estate planning tools. 1, we are talking about wills. We talk about trusts. We talk about advanced healthcare directives. Then we talk about powers of attorney. We talk about the guardianship of children. We talk about property ownership regimes. And then we also talk about business succession. What happens to your business once if you unfortunately pass away? So I'll start by one of the most common documents that we know. We talk about wills. We have 2 types of wills. The first type of will is called a written will, and then we have an oral will. What is an oral will? An oral will is a will that is made by mouth. It must be before 2 or more competent witnesses, and the person who is making the will would need, it has a validity of 3 months. So if the person doesn't die within 3 months, they need to make a new will or just do a written will. As simple as that. Now let's talk about a written will. What is a written will? We know, of course, it is writing. For it to be it is in written form. It must be signed by the person who's making the will, that is the testator, and it must be signed by 2 or more witnesses who are called competent witnesses. And the third thing is it must name an executor. This executor is someone who will give effect to the will. The executor will go to court and get a grant called a grant of probate that will then be able to give them power to administer the will. If you have a will, it is signed, there are 2 witnesses, but you do not have an executor. What happens is your family or friends or whoever it is will have to get letters of administration in court. And that's a longer process. So why not just mention an executor of your document? So when we're talking about provisions of a will, you need to be able to provide for your wife, their wife or wives, former wife or wives and children, and you also provide for your parents, step-parents, grandparents, grandchildren, brothers, sisters. But there is one major distinction here, that when you're providing your wife or wives or former wife or wives and children are entitled by right to inherit from you. But your parents, step-parents, or extended family can only inherit from you to the extent that they were being maintained before your death or before the person's death. That is the difference. So we've talked about wills. I'm moving on to talk about trusts. A trust is the second document in an estate plan. It's a second tool that we use to plan your estate properly. And it creates a relationship between a grantor, trustee, and a beneficiary. So in Kenyan law, we've probably heard the word grantor. Others call it a settler, others call it a trustor. But it is a legal relationship where you have a beneficiary set somewhere, and you also have property somewhere that you want to put in a trust, and you have trustees to manage that property on behalf of a beneficiary. Let's talk about the types of trusts. We have 3 types of trusts. 1, we have family trusts. 2, we have charitable trusts. And 3, we have non-charitable trusts. For purposes of estate planning, we focus more on family trusts. These are trusts for purposes of managing a family, the assets of a family. Charitable trusts are trusts that do a charitable purpose, maybe helping the less fortunate, benefiting the society, as well as non-charitable trust is purely for making money or holding property. So when we're talking about family trusts, a family trust can either be a living or a testamentary trust. A living trust is a trust that takes effect even when the trustor or the grantor is still alive. So you can create a trust that takes effect while you're still alive, that becomes a living trust. Or a testamentary trust is a trust that takes effect upon death. A trust can either be charitable or partially charitable. A family trust can be partially charitable or completely non-charitable. If it is partially charitable, that means you've put in some charitable activities that it will do. The advantages of having partially charitable trust is that you're able to get some tax exemptions. For example, you can apply for exemption of stamp duty payment. You don't have to pay stamp duty when purchasing property. You can apply for import customs exemptions. You can apply for exemptions from paying property rates as well, to the extent that it is doing charitable purposes. And you can set up the trust as an individual, a trustor or settler, or in a community or in a group of people. And a family trust exists solely for the purposes of planning and management of family property. So how does a trust work? A trust works because of three individuals. We have a trustor, who can be yourself, a trustee, and a beneficiary. That is a trustor, trustee, beneficiary. So the trustor sometimes can also double up as a trustee, but for purposes of estate planning, we discourage that because we want this trust to outlive you. It is designed to be able to outlive you. So have separate trustees who can be paid or not paid, and beneficiaries for the same. So what are the advantages of a trust? Is one, you have control of property while you're alive. Two, it helps you avoid lengthy succession battles. And three, tax benefits, especially where the trust has some partially charitable aspects of it. So what are the three steps that we take in the setting up of a trust? One is we do a trust deed, we register a trust deed. Two, we petition for the incorporation of the trust after the trust deed has been registered. And lastly, we then transfer property and assets to the trust. So we have talked about wills, we've talked about trusts. Then now we have the third aspect of estate planning is through property ownership regimes. I'll tell you what property ownership regimes are about. We have two types of co-ownership of property. Well, co-ownership is where you own property with someone else. The first is through joint ownership, and the second is through common ownership of property. I'll tell you the difference. They almost sound the same, but I'll tell you the difference between the two, between joint ownership or joint tenancy and common ownership or tenancy in common. In joint ownership, you own this property with someone else, but there is no acreage allocation in the title deed. So you'll have the title deed saying Elvis Abenga owns this property with John Doe. But it doesn't say that Elvis owns half of the property or Elvis owns a quarter of the property and John Doe 3/4. Or it doesn't say Elvis owns 0.5 hectares and John Doe owns 3.5 hectares. There is no acreage allocation. What that means is when we jointly own property, whenever one person dies, the other joint owner automatically gets that property by way of what we call transmission through survivorship. So if I want to leave property to my child and my child is of age, if I don't want to leave that property through a will because I think somebody will challenge the will and it will become a whole lot of a process, and I don't want to set up a trust because I don't trust my trustees, I can have this property registered in joint ownership between me and my child. So that if God forbid I pass away, the property moves straight to the child. Anything the person does is he or she goes to lands, fills in an application for transmission of the property through survivorship, and the property moves. As simple as that. Nowadays, it becomes more and more common to use this method as a method of estate planning because it avoids a lot of drama, avoids succession processes by all means necessary. Ownership in common, on the other hand, is where you own property with someone, but then there is an acreage indication. There's a proportion that is indicated in the title deed. For instance, someone says, you know what, you own 1.5, you owe half, and all that kind of stuff. The thing is, where there is an acreage delimitation in the title deed, when one person dies, their portion of the title, their portion of the property can and will be subject to succession processes. So if you want to avoid succession process, go for the joint ownership regime as opposed to ownership in common. I want to talk about a power of attorney. What is a power of attorney? We know about a power of attorney. A power of attorney is a written authorization given to someone else to act on your behalf in a specified or general setup. It is prepared for convenience purposes due to unforeseen circumstances, and it comes to an end upon a person's death. So when you're talking about unforeseen circumstances, sometimes you want to travel out of the country, or you feel like you may not be in a position to sign some documents. So you get a trusted person, you do a power of attorney for them, and when you do this, you are able to make provision for them. They're able to act on your behalf when you're incapacitated. We have two types of powers of attorney. We have the first one is called a revocable and irrevocable powers of attorney. A revocable power of attorney is one which you can withdraw. You can call it back anytime. An irrevocable power of attorney, on the other hand, you can't revoke it. There is a current case at the Court of Appeal challenging the regime of irrevocable powers of attorney. Still under debate in the law, but generally you have the power to call it back if you feel maybe your attorney is not now acting in your favor. And then we have general and limited powers of attorney. What these are is a general power of attorney will enable you give a blank check to your attorney to do all lawful legal acts that you are able to do. But a limited power of attorney is limited to purpose, maybe purchase of some property, maybe it's holding some funds, maybe it's getting into some transaction. It is of a limited purpose. The next tool that we use in estate planning is called healthcare directives. This is a new kid in the block. It just came into Kenya recently. It is gaining popularity. I want to tell you what a healthcare directive is. A healthcare directive is also known as a living will. This is where you express your desires regarding medical treatment in the event that you're incapacitated. If you're under life support, do you want to be kept under life support for 3, 4, 5 years, or do you want to end it quicker? Do you want to be treated from home or in hospital? Do you want, some people do put indications that they do not want to be taken through a blood transfusion. Some say they do not want a surgery to be done to them for religious reasons, maybe. So these are called healthcare directives. You can be able to do that if it's important to you. And when you are doing a healthcare directive, and you would need 3 documents. One is a power of attorney, which we have already talked about. And the power of attorney, you appoint an attorney who will give effect to that directive, and then you do a letter of instruction, and lastly, you have a properly witnessed healthcare directive. It's a document by itself where you now stipulate, and it is witnessed and signed by witnesses. When you have these 3 documents, your power of, and God forbid something happens to you, your lawful attorney can be able to present them to a hospital, and they will listen to and follow your directives. Disclaimer: they only do it to the extent legally and ethically they are allowed to do. You cannot put in, for instance, a do not resuscitate a request, also known as a DNR. You cannot put a request to commit suicide, for instance, or assist euthanasia. Those are illegal in Kenya, so the hospital will disregard. So they will only agree to directives to the extent that they are legal in this country. Let's talk about guardianship of children. So while you're planning for your assets, you've planned your assets, you've put some of the assets in a will, you've put others in a trust, others you've put in jointly owned properties with the people you'd like to give those assets to in the event of your death. What happens to your children, especially minors? And maybe you have a parent, you're co-parent. Maybe you're not together, or maybe you are, but you feel like they may not be a good parent, or they may not be able to take good care of these children by themselves. You do what we call a deed of guardianship. In a deed of guardianship, you specify the person who will take guardianship of children in the event of your death. Who will do it? So what it does is it works where a parent is unsure that the other parent will take good care of the children alone. So you appoint a guardian who will act as a guardian in the best interest of your children alongside the other parent. This is a legal process, and it becomes legal. If you have that good friend that you know I can trust my children with, that is the person you do a deed of guardianship for. What are the requirements? 1, the deed must be signed and sealed properly for it to be a deed. You must be able to appoint a testamentary guardian. It must be witnessed by at least 2 witnesses. Whether a testamentary guardian is that person, that friend we're talking about, who will take responsibility upon your death. Testamentary is upon death. And then the deed of guardianship may be registered or not. It's advisable for it to be registered, but it is not a prerequisite. Lastly, as you're planning all these things, think about succession, business succession planning. What happens to your business when you're not there? Do you want it to outlive you, or do you want to close it down? If you want to your business to outlive you, what do? We first set up a trust for you. And once we do that trust setup, we then transfer property. Sorry, not property. We transfer shareholding to the trustees. The trust will specify how your business will be handled upon your passing away by your trustees. And now, when the trustees are now shareholders, they are able to give effect to what you have decided or what you have set up as a trust. Thank you for listening to this webinar, very briefly as such. So just to remind you, we have the following tools that we use in coming up with an estate plan. We've talked about the first one, having a will. We've talked about having A trust, a family trust, we've talked about having joint ownership of property and not ownership in common. We've talked about uh, guardianship of your children when you've setting up a testamentary guardian for your children. We've talked about business succession planning. All these tools are useful to give you some peace of mind uh, as you live your life, knowing that your property and your loved ones are well taken care of. So there are a few questions I can see. I will answer some of them as much as I can. Please keep posting. The first question someone is asking, must a written will be deposited at the central registry? A short answer to that is no. Initially there was a requirement, but now it is not required. A will doesn't need to be deposited at the central registry. You just do it for as long as you have the prerequisites for it, it will still be held to be a valid will. Someone is asking, can couples have joint wills? No, a will is an individual event. According to the Law of Succession Act, you only do it by yourself. Can a trust be set up from a deceased person's will? Yes, a trust can be set up from a deceased person's will. It is called a testamentary trust. It is possible, especially if the prerequisites are met. For what is the legitimacy of wills of wives? Sorry, the legitimacy of wives. I will say that previously, under the Law of Succession Act as it reads, even former wives can inherit. A wife has to be a wife under the Marriage Act. That is one of the new developments in the law. And you know, the Marriage Act recognizes wives who have a marriage certificate. Even for customary marriages, nowadays you need a marriage certificate. There is a case challenging the issue of former wives and their ability to inherit, but the Law of Succession Act has not yet been amended enough to allow for that. Someone is asking, are children looked in totality even outside marriage? Yes, they are. A child is a child, whether born in marriage or outside marriage, that child has a right to inherit. Borderline for provision of extended family. I think someone is asking, to what extent do we say that we've provided for extended family? I will answer this in a nutshell. Yeah. For an extended family member to classify as a dependent, they must demonstrate that the deceased person was taking care of them on a regular basis without interruption, and that the deceased took care of them immediately before death. When they can be able to fulfill that, then yes, they can be able to claim some kind of provision. A question, can joint ownership be between parents and children? Yes. Joint ownership can be between parents and children, especially if children are adults, but if not, then the property will be held in trust for them. Someone is asking, what is the timeline for challenging a will? There is no timeline. Wills are challenged every once in a while, and yeah, a short answer is there is no timeline. So, as we go through the rest of the questions, I'd like to give you a gift for being a very loyal follower and following through this process and this webinar. We are having, as BEGI'S Law Offices and Chambers, a 1-month estate planning drive. That means we plan your estate within 1 month, draft the papers, do it all the things for you at a cost of 50,000 shillings. Normally it costs quite a bit to do estate planning. But for purposes of this webinar and for the participants here, we are giving you a discount and doing a complete estate plan for you at 50,000 shillings. And this offer is valid until 5th of February 2025. Pass the word around and we would be happy to help you. These are our contacts. BEGI'S law offices and chambers. We are at second floor Bishop's Garden Towers, First Ngong Avenue, Upper Hill, Nairobi. Our email is there, info@begislaw.com. Phone number 0723 31 38 33. And you can always check us out online at www.begislaw.com. I would want to end at this point and thank you so much. I do not see any further questions here. Thank you so much for being a part of this process. I will just put in a poll where you can be able to give your remarks on whether this has been a valuable experience for you. And I look forward to being able to see you in our next webinar. God bless you. Have a lovely rest of your night.